disputes. He was the president of the Law Society of Hong Kong from 2016 to 2018 and is a solicitor advocate with rights to appear in the higher courts of Hong Kong. So Thomas, I'll pass it over to you.
Thank you, Jodie. Welcome all to Capsule 3. We're going to have a number of very eminent speakers to speak to us on the UN Convention on International Settlement Agreements resulting from mediation, which is, the short form is Singapore Convention. Okay. You can see from the slide that we have 5 eminent speakers. We have Mr. Ted Lim, Mr. Michel Calapetis, Ms. Corinne Montineri, Mr. Alan Stitt, and Mr. Joe Tirado. I shall introduce each of them in more detail before they speak on their subject. To start, I think I would like to first acknowledge the contribution of all the sponsors whose generosity has made this webinar possible. Their logos can be seen on your screen now. We can now proceed with our first speaker, who will be speaking on the purpose and reasons for the convention, recent development and its relevance to the UN agenda. Oh, sorry, am I supposed to do this slide? Right, okay. We can move on to the third page. Ms. Corinne Montineri. Let me do a bit of introduction about Corinne. Of course, many people, already know Corinne. She is a senior legal officer in the International Trade Law Division of the United Nations Office of Legal Affairs, the Secretariat of the UNCITRAL. Her main field of activity relates to dispute settlement and technical assistance to law reform in the field of arbitration and mediation. Corinne has been servicing the sessions of the UNCITRAL Working Group 2 dispute settlement since October 2003. And now she is the Secretary of Working Group 3 in Investor State Dispute Settlement Reform. Ladies and gentlemen, I shall pass it on to now Corinne for you to speak on your topic. Corinne, please.
Thank you very much for the kind introduction, and hello everybody. It's a real pleasure to be today with you all here. So we are going to present to you the Singapore Convention on Mediation, which is a convention that has been developed following an intergovernmental process within the United Nations. This convention has been adopted by the General Assembly of the United Nations in December 2018, and it is considered an instrument for the facilitation of international trade and for the promotion of mediation as an effective method for resolving trade and also investment disputes. So you will see with the first speaker that this convention is quite innovative and that it brings what was missing in the international community, which is an effective mechanism for the enforcement of international settlement agreements resulting from mediation. So when it adopted this convention, the United Nations General Assembly expressed its conviction that this convention, and I quote, will contribute to the development of harmonious international economic relations, which is indeed something we need. So the contribution of the convention to the UN Sustainable Development Goals also deserve to be underlined, and we will do that briefly in a moment. So if we go to the next slide, you will see that the convention, as I said, was first adopted by the UN General Assembly in December 2018, and then it opened for signature in Singapore in August 2019. And the government of Singapore has hosted the signing ceremony, and that's where the name of the Singapore convention comes from this signing ceremony hosted in Singapore. The convention entered into force in September 2020, on 12 September 2020. And you will see from the next slides the map showing the countries that have signed the convention already. We have 53 countries from various continents, various parts of the world. So it's a great success for this convention, which is 1 year after its opening for signature already in force. And it is not so usual for conventions in the field of trade law. So we can move to the next slides, and you will see that before we reach the stage of a successful unanimous adoption of the convention by the UN General Assembly, we went through a negotiation process which was hosted by one of the commission of the General Assembly, which is UNCITRAL, the UN Commission on International Trade Law. I think you must know UNCITRAL for its text also in the field of international arbitration. UNCITRAL has been there since its establishment by General Assembly resolution in 1966, and the mandate given to UNCITRAL was to promote the harmonization, modernization of international trade law. So UNCITRAL has been actively working in the field of international dispute resolution, which is, of course, a very important factor in the development of international trade. And you may know that UNCITRAL is also in charge of the promotion of the New York Convention on the recognition and enforcement of foreign arbitral awards, which is a founding convention in the field of international arbitration. And that New York Convention has also served as a model or a reference text for the preparation of the Singapore Convention. So you see, for more than 50 years, UNCITRAL has been functioning as a platform where states can peacefully find solutions to problems that arise in international economic relations, and that can be more efficiently resolved on a multilateral basis. So the Singapore Convention, like the other texts of UNCITRAL, are developed with universal participation from states, and states' delegation can be composed of civil servants, but also academic practitioners. And we have also the participation of international, intergovernmental, and non-governmental organizations with relevant expertise. And during the drafting process of UNCITRAL instruments, the differences between the national systems are considered, and the solutions compatible with different legal traditions are usually reached, and this is reached based on consensus. And on our panel today, we have a number of distinguished past delegates to Working Group 2, which is the UNCITRAL working group which worked on the development of the convention. And so they can give you some insider's views maybe later on how the process unfolds. So now to the convention itself. The work on the convention started with a proposal from the government of the United States of America in 2014. And you know, when the proposal was made that a convention should be developed for the enforcement of international settlement agreements resulting from mediation, this was welcomed with a number of questions, and delegations expressed doubts. And the questions were, for instance, whether the new regime on enforcement would be optional in nature, because mediation is very flexible, whether the New York Convention would be an appropriate model for work in relation to settlement agreements, whether formalizing the enforcement of settlement agreement would in fact diminish the value of mediation as resulting in contractual agreements, whether complex contracts with conditions and so on would really be fit for this type of treaty, and what would be more generally the legal impact or implications of such a convention in the field of mediation, because mediation is known for its flexibility, agility, and so on. So these were quite deep questions that the delegations looked at, went through, and if you want to see more on that, you can have a look at the travaux préparatoires of the convention, which provides a summary of all the deliberations. And from these questions and from the deep consideration of what mediation is, what the convention is, what it can bring, delegations work to find the right balance between the need for legal certainty in the enforcement of settlement agreements, but also the flexibility that should be provided given the consensual nature of mediation. So legal certainty and flexibility were the guiding principles. So you will see how these principles translate in the contents of the convention. As I mentioned, the convention mainly aims at enhancing the enforceability of settlement agreements reached through mediation, and also at facilitating the possibility for a party to invoke a settlement agreement as part of a procedure. So the uncertainty surrounding the enforcement of settlement agreements has constantly been mentioned as a main obstacle to the greater use of mediation. And this is in response to the need of easy and fast enforcement that the convention was developed. As you will see from the presentations later on, the convention clearly sets the principle for enforcement and for invoking a settlement agreement. It also sets the requirements for reliance on settlement agreements and the grounds for refusing enforcement. The convention provides so clear and simple mechanism on enforcement, and it avoids the recourse to burdensome domestic enforcement procedures. So that's for the legal certainty. And aside from the legal certainty brought by the convention, you have also a level of flexibility which is provided to states, but also to disputing parties. First, the convention focuses on the enforcement of settlement agreement instead of the rules of the mediation process. Second, the convention only contains limited form requirements for the settlement agreement, and the sole purpose of the requirements mentioned is to clearly distinguish these agreements from other agreements. And third, the convention also allows for the application of a more favorable law or treaty for achieving expedited enforcement of settlement agreements. So it means that if a state to the party to the convention has a legislation which is more favorable than the convention, then that legislation will apply. And also the convention does not go into any procedural details. It foresees the application of the procedural rules of the states where the convention is silent. So in addition to this intrinsic characteristic of the convention, UNCITRAL has developed two instruments in parallel. The convention, and the convention really provides a uniform framework, and also an amendment to the model law on conciliation that was prepared initially by UNCITRAL in 2002. And the amendment to the model law consisted in the addition to a section on enforcement of settlement agreement to mirror the provisions of the convention. And that's the first time UNCITRAL is doing two texts of a different nature in parallel. And such multilateral lawmaking process provides states with the flexibility to adopt either the convention, to enact a legislation based on the model law, or to do both, And if they do both, then they have a very comprehensive framework, legal framework on mediation. Of course, the two texts are consistent, but they are of different nature. So the model law provides flexibility to lawmakers because you can diverge from the model when you enact a legislation. The convention provides for limited reservations, and so you will reach a higher degree of harmonization with the convention. So what was expected in doing that is that the Singapore Convention on Mediation and the model law, both texts, will accommodate the different levels of experience with mediation in different jurisdictions, and will also encourage the use of mediation and will ensure greater predictability and certainty in the use of mediation. So, in addition, let me briefly mention the aspects of the convention regarding its relation to the 2030 Agenda for Sustainable Development. This is to give you a wider framework, and I think it is important also when you are a practitioner in mediation to have this wider picture in mind, even if you don't need that on a day-to-day basis in your activity. First, and you all know that, so it will be so obvious what I'm going to say. Mediation is known for its significant benefits, such as reducing the instances where a dispute leads to the termination of commercial relations. It facilitates the administration of international transactions by parties, and it also allows savings in the administration of justice by states. So it is expected that the convention will contribute to the sustainable development goal of providing access to justice. Second, the convention, by promoting the settlement of disputes based on party autonomy, will encourage amicable settlement of disputes and the preservation of long-term relationships. And that preservation of relationships serves the sustainable development goal of building peaceful and inclusive societies. And third and last, also, the convention is expected to bring certainty and stability to the international framework mediation, thereby promoting more stable and sustainable international trade relationships among states and regions, contributing to economic development and maintenance of peace at its level, of course. So what we hope is that this convention will lead to the universal recognition of mediation as a powerful dispute settlement tool, and that it will support the wider use of mediation as a very efficient and non-confrontational method for the settlement of trade and investment disputes. Now, it will be for the mediation community, all of you and the organizations and so on, to really promote this convention, ensure its smooth implementation. We will most probably, when time will come, need to do some training to the judiciary, as we have done with the New York Convention, to ensure that, or to respond to questions that judiciary may have on that convention. There's a lot of activities that can be developed, and we can build on experience we have on similar convention. But it is in force already and can be already applied. So we are waiting to see whether there will be cases. I would like to add that conferences like this one are very important for raising awareness on this text and what it can bring. And with that, I would like to thank you all for your attention.
Thank you, Corinne. Thank you very much for your speech on this topic. The next speaker that we have is Mr. Michel Kalipakis, QC. Michel has been a practicing barrister for 40 years, with 15 years sitting as a Deputy High Court Judge in the Queen's Bench, Chancery and the TCC. 12 years ago, he founded Independent Mediators Limited and practiced as a full-time mediator. He is recognized in the legal directories as an expert in this field in mediation in the UK and internationally. Michel is also a member of the working party that drafted the EU Code of Practice for Mediators, and he was a representative at the UNCITRAL Working Group 2 that drafted the Singapore Convention for the Enforcement of International Commercial Mediation Settlement Agreement, the convention that we are discussing today. Over to you, Michel, for your topic. I understand that you're going to tell a story which will take us through your slides. It's over to you then, Michel.
Thank you, Thomas, and good afternoon, good evening, or good night, whichever the applicable time of day is for you all. What I thought would be quite useful for us all is to understand how this convention was fashioned in the way that it was. It has received some criticism from people who simply looked at the words and didn't understand what was behind it. I was drafted in by Alan Stitt, one of my mentors and indeed trainers as a mediator years ago, with the message that the UK was not represented at the working group sessions, and it was in danger of collapsing because people didn't understand mediation. And of course, there were people at the working group who did know what mediation was about, but I think it's fair to say that they were in the minority, certainly in terms of practical experience. As Corinne mentioned, there were three tensions which became readily apparent to me when I went to Vienna for the first time. And by that stage, the first sections of the convention had already been drafted and effectively agreed. And the tensions were these. The desire was to try and produce a convention in the same model as the New York Convention for the Enforcement of Arbitral Awards for settlements arrived at international commercial mediations. Now, I emphasize all three of those words: international, commercial, and mediation. And so it was not designed for small disputes, family disputes, domestic disputes. And as we shall see when we look at the detail of the convention itself, those are expressly excluded. The second tension that was apparent was the desire of some of the delegates to have a model law and not a convention, and the others who wanted a convention and not a model law. And this argument raged, I think, for at least two of the working group sessions until, with sensible compromise, the Secretariat suggested we drafted both, and that's what we did. And whilst I'm mentioning the Secretariat, they did a remarkable job. Anyone who's been to a convention of United Nations will know that it is very much like a boxing match, except that people are in separate rings throughout the whole of the hall where it's taking place, and everybody has their own agenda. And I shall show you in a moment what happened, which developed a consensus for the rather contentious arguments about defense. And the third tension was, of course, that United Kingdom at that stage was still in Europe, although the disastrous vote to leave had already been taken. But the official line from the UK government was that they were adhering to the EU line, and the EU line did not want a convention. And so with that sort of background, and I sat in amazement for the first day or two in Vienna, listening to people talking about mediation as if it was an arbitration. And we had discussions about traffic lights warnings, the biases, the declarations of independence, and this went on for certainly a whole of one session. But let's see what happens at the end of the day. First of all, the convention applies, and if I can ask CW perhaps to show the screen with the slide M1. I haven't got that on mine. Can you? There we are. Thank you. the convention applies to an agreement resulting from mediation and concluded in writing by parties to resolve a commercial dispute, and that's referred to as the settlement agreement. And this is the important part, which at the time of its conclusion is international. Now, I emphasize the word conclusion because very often, as experienced mediators will know, these disputes can not be settled in one day, but can sometimes take several days, weeks, even months, and one I know of, several years. And so the important time is when the agreement is actually signed, where it's signed, then it's international. And under international, if you look at the next slide, you will see it's at least two parties to the settlement have their places of business in different states, or onto the next slide, you will see the state in which the parties to the settlement agreement have their places of business is different from either the state in which the substantial part of the obligations under the settlement agreement is performed, or the state with which the subject matter is most closely connected. So that's the definition of international. And again, we're talking about commercial agreements, not domestic. And on the next slide, you will see that expressly it doesn't apply to settlement agreements arising out of transactions for family, personal, or household purposes, or related to family, inheritance, or employment law. Nor does it apply to a court-approved settlement agreement enforceable as a court judgment or arbitral awards. And if you see the next slide, you will see that each party to the convention is given the freedom to enforce a settlement agreement in accordance with its own rules of procedure and under the conditions laid down in the convention. And we will know once people start ratifying them. Now, to enforce it, the party seeking to enforce a settlement agreement must produce to the competent authority, first of all, the settlement agreement signed by the parties. And let me emphasize there, order agreements won't work, simple handshakes won't work. It has to be in writing for obvious reasons. And evidence, in addition, that the settlement agreement resulted from mediation, such as the mediator's signature on the settlement agreement. Now, pausing there for a second, that caused a lot of discussion. Most mediators will not sign the settlement agreement. The settlement agreement is between the parties, and most mediators won't lend their signature to the agreement, which in some way might indicate that they are responsible for the drawing up of the agreement or are party to its terms. And that's an essential requirement for most common law countries, where mediators will not leave themselves open to an action if something goes wrong with the enforcement of the settlement, or be blamed, and I use that word advisedly too, for the language that's used. It's for the parties' lawyers to draw up the agreement, and therefore the mediator's signature was put in as, if you'll forgive the word, a sop to those countries that insisted that the mediator had to sign it. Otherwise, there was a danger of a fraudulent agreement being produced by somebody simply producing a written document signed by anybody. The second requirement, or the alternative, is a document signed by the mediator indicating the mediation was carried out. That, I think, was a suggestion that came from the mediators to simply say, look, all international commercial mediations are conducted pursuant usually to a mediation agreement between the parties and the mediator. And the mediator signs the agreement, I do all mine, I know Dos Allen, and most mediators I know actually sign the mediation agreement, which is also signed by all the parties. And that's sufficient evidence that a mediation took place and a settlement arrived as a result of it, because in the settlement agreement itself, there will be a reference to the settlement having been concluded at a mediation conducted by, and the mediator is normally named, and then the date or dates on which the mediation took place. A third is an attestation by the institution that administered the mediation. So if the mediation took place under the auspices, for example, of the ICC or any of the international organizations that appoint mediators to disputes, then a document from there that the mediation took place by the person named and involving the parties named would be sufficient. And again, to settle the arguments that raged about the implausibility, the impracticality, and the impossibility for some of them, these conditions to be satisfied, compromise in the absence of any of those three, any other evidence acceptable to the competent authority. So again, the judge or the court being asked to enforce the agreement may have its own rules as to what is acceptable as evidence that a settlement agreement was reached under the Singapore Convention. And then moving on to the next slide, that when I was in New York happened on the Thursday. And I'll explain the relevance of that in just a moment. I'll come back to that particular slide, but that was the view from my hotel window when I woke up. New York was hit by a snowstorm, a whiteout, and everything closed. And the United Nations building was shut for the day, not least because it would be dangerous for some people to get into work. And moving on to the next slide, at that stage, we had reached the point, and that's the argument that goes on in a United Nations working party. Every country you'll see has their own desk screen, and there are two large screens, and there at the back is the secretariat, and there I think is Corinne sitting in the middle next to Natalie, who was the chairperson, and I can't see who that is, but they were remarkable, the secretariat. They were able to listen to all the debate, and they produced a summary, which was, quite frankly, almost magical in the way that they were able to draw together all the arguments and produce a coherent argument. The biggest argument in New York, which started in Vienna, but really took place in New York, was over the defenses. The defenses being raised, and Article 5 is the one that's caused a lot of debate and dispute and comment by academics and mediators. Court can refuse to grant relief, i.e. to enforce the settlement, if the party to the settlement was under some incapacity, otherwise not able really to sign an agreement. The settlement agreement is null and void, inoperative, or incapable of being performed under the law to which the parties have validly subjected it, or for any indication under the law deemed applicable by the competent authority of the party to the convention where relief is sought under Article 4. Or it's not binding, or not final, it's only a draft, or it's been subsequently modified by agreement, or the obligations have already been performed, or they're not clear or comprehensible, or granting relief would be contrary to the terms of the settlement agreement. For example, if somebody is seeking to enforce a settlement agreement, which was expressly excluded or compromised by the settlement agreement itself, then that would be a reason for the court or the competent authority to refuse to implement the settlement agreement. But the real debate, which raged, and I use the word raged advisedly, for a full day on the Wednesday, was over arguments raised about the impartiality of the mediator, supposing a mediator was dishonest, supposing a mediator had failed to disclose a vital matter which would go to his neutrality. Now, again, all these arguments were redolent of the debate that's been raging in the international arbitration world over the independence and impartiality and the need for disclosure by arbitrators. We had the green light, the orange amber light, and the red lights for indicating impartiality or bias. And all of these, of course, overlook the essential feature of mediation, and particularly an international commercial mediation. International commercial mediations between corporations invariably have teams of lawyers on both sides acting for the parties. The mediator, again, was one of the misconceptions of so many delegates, does not decide matters. There's no arbitral award. There's no decision deciding issues between the parties. The parties fashioned the agreement themselves. And there were some people in the working group that couldn't grasp the difficulty that if you divorce the judgmental part of the proceedings which they had in mind, then there's no need for the issues relating to defense, which would arise in an arbitration. You can challenge an arbitral award on the grounds the arbitrator was biased, he was incompetent, or he had failed to disclose a matter which went to his independence. But for mediators, that isn't strictly speaking necessary. And the idea that international corporations, advised by teams of lawyers and often experts, could claim that somehow the mediator's failure to disclose that his pension fund had shares in a subsidiary company of one of the parties will be a matter which would disqualify him from acting as a mediator was in fact too fanciful for words. Just please go back to the previous slide. And so what was devised, and it was divided in this way, that at the end of Wednesday, we had got to a situation where something had to be done because there had to be a compromise between those who insisted, and indeed had government instructions from their own government, that there had to be precautions against misbehavior, misconduct, or a non-disclosure by a mediator. So then we go back to the snowstorm. Thursday, shut down. The day when we were supposed to discuss it all was a complete washout, I should say snow out. Mercifully, Alan Stitt, who was the Canadian government delegate, called up a friend of his who had offices in New York, who again was closed for the day because of the snowstorm, and they made available their large boardroom, and phone calls were made around to all the delegates we could get hold of. And all the material parties to this particular dispute met in the offices of this law firm, who very graciously gave us the facilities of their offices for the day. And the secretary came along, kept us sustained with New York delicacies from the local delicatessen, and anybody been to New York deli will know that they are fairly substantial and delicious. And the remarkable thing was this: if you remember the slide where everybody was sitting behind their own little castle and their own little screen and in own individual sections, that is an arbitration, it's a discussion, it's effectively a negotiation. I compare it to trench warfare in the First World War, where each army was buried in the trenches and occasionally put their head over the parapet. By sitting around a table, cheek by jowl, social distancing wasn't relevant in those days, thank God, and talking to each other as people do in a mediation, all the delegates suddenly realized that's exactly what they were in. They were no longer in a negotiation. They were no longer in a rather disagreeable discussion at some times, but they were in a mediation. And people were far more frank with each other, sitting around that table, all without prejudice, discussing with each other their particular difficulties, their own government briefs, and the necessity for fashioning sections which would deal with the direct commands from some of their ministries of justice that there had to be precautions against a rogue mediator. Eventually, it was realized that the only relevance of all the arguments that were being raised was whether or not the consent of the party who was seeking to raise that particular defense to enforcement had been vitiated by the conduct. And thus it was that we came up with the two sections. And if you look at section E first, please, back one slide. Can we go back to the previous slide, please, see, Sam? Yes. This dealt with mediator misbehavior, which was being promulgated as a reason for setting aside a settlement agreement. And so these were the words that were eventually arrived at as a compromise. There was a serious breach by the mediator of standards applicable to the mediator or the mediation, without which breach the party would not have entered into the settlement agreement. Now, the important words that are there are serious. So it's not any trivial breach. It's got to be something that's really substantial and serious. The standards applicable cannot be identified because every country has its own mediation standards. The universal standards, of course, are impartiality, neutrality, and adhering to the rules of the mediation agreement. But the important concession that was made and the compromise that was arrived at, that but for that breach, the party has to demonstrate that it wouldn't have entered into the settlement agreement. Now, bearing in mind that these are international commercial organizations, flanked by teams of lawyers on either side and experts, the prospect of any one of those being able to persuade a court that the mediator's failure to say good morning to them politely, or speak to their lawyer rather brusquely, or challenge a legal position that's being put forward, all the things that go on in international mediations when the mediator is testing the parties, gathering facts, making sure that he understands their position, and making sure that arguments put forward by each side are properly understood and answered. All the things that do happen without him making a decision, but challenging and testing, reality testing is the buzzword. That those didn't actually impinge on the consent of the party entering into agreement. And again, bear in mind that the agreement has to be drawn up by the lawyers, and the lawyers again have a duty to advise their clients on the settlement agreement. And any party that tries afterwards to say, well, the mediator was very rough with my lawyer and didn't believe what he was saying, and that vitiated my consent. Well, I mean, I've only got to adumbrate the argument for you to realize that the likelihood of that ever happening, I think, is fairly remote. But that wasn't the end of it, because we then had to deal with the question, if we go on to the next section, of the failure to disclose. And so the competent authority of the party where relief is sought may also refuse to grant relief, i.e. enforce the settlement. I'm sorry, no, that's not the one. Please go back to F. Can you go back to the previous slide, please, Sam? Yes. There was a failure by the mediator to disclose to the parties circumstances that raised justifiable doubts as to the mediator's impartiality or independence, and such failure to disclose had a material impact or undue influence on a party, without which failure that party would not have entered into the settlement agreement. Now again, you'll see that that is a compromise, but examine the words carefully. Circumstances that raise justifiable doubts. And that means not fanciful, justifiable. And of course, it's an objective assessment by the competent authority. To the impartiality or independence, such failure to disclose had a material, and again, not any, but material impact or undue influence on a party, without which failure that party would not have entered into the settlement agreement. So again, vitiating consent is the watchword and the basis of that particular section. If we move on shortly, the other defenses that can be raised, as you'll see in the next slide, are the ones that the competent authority grant relief be contrary to public policy, the subject matter of the dispute is not capable of settlement under the law of that party. Moving on, please, to the next slide. Sam, can we have the next slide, please? Yes. So this is the summary. The three essential principles of granting relief. Any alleged breach or failure must be material. The materiality is to be judged objectively, and the applicant must establish the alleged breach or failure vitiated their consent. And equally for the next section on the next slide, there's a serious breach of standards, without which that breach would not enter into the agreement. Again, next slide, please. the outline there, failure to raise circumstances, justifiable doubts, material impact, undue influence, vitiating consent. And the next slide, please. In summary, and if you'd like to note down that that particular slide refers, of course, to Article 5.1e, and emphasize the three main words: serious breach, standards, vitiating consent. All three elements have to be established by anybody seeking to rely upon that section as a reason for getting out of a settlement agreement. And again, if you look at the slide number 20, please, justifiable, material impact or undue influence, consent vitiated relates to 5.1f. Again, the party seeking to avoid the obligations of a settlement agreement has the burden of proving that there's a justifiable failure which had a material impact or undue influence, such as to vitiate their consent. Again, just have in mind written agreement drafted by lawyers and advice by lawyers who are independent, of course, of the mediator. So that effectively led to the compromise which was thrashed out in that office in New York, where the snow raged outside and we were kept alive by the good offices of the Secretariat, who not only noted all the discussion and drafted down the compromised words, but also fed us with delicacies from that deli around the corner, which remained open. Alan, I think now will deal with the reservations, otherwise referred to as the opt-in, opt-out dispute.
Thank you, Michelle. The next speaker we have is Mr. Alan Stitt. Alan is the president and CEO of ADR Chambers, the largest private alternative dispute resolution service provider in the world. ADR Chambers has administered thousands of mediations and arbitrations over the years. Alan is a mediator, arbitrator, negotiation consultant, facilitator, trainer, and ADR systems design specialist. He has written extensively on the subjects of mediation and arbitration, and he has taught ADR and negotiation courses throughout North America, Europe, Asia, Africa, and Australia. Over to you, Alan, for your topic on reservations.
Thank you, Thomas. And it's a pleasure to be here. I want to say a few introductory comments first about the convention. When we started our meetings, there were really, as Michelle mentioned, two teams with two different philosophical approaches. There were those of us who wanted to assist the parties who were trying to enforce agreements reached at mediation and needed some assistance with that. And there were the group of people who wanted to help the people who wanted to get out of the agreement they reached at mediation. And if that sounds a bit absurd to some of you, it sounded a bit absurd to some of us at the time, but it was the situation we had to deal with. The part I wanted to add was, for me, I think I had a larger objective, and my objective was to help the people who wanted to feel confident that their agreements reached at mediation would be enforceable. And for me, the feeling of confidence was more important than the actual mechanisms in this convention or model law for enforcement. And so what I think is really important for everyone to take out of this is that the importance of the Singapore Convention is the perception of how effective it is. And that's a lot more important than the actual reality for the convention, because as we know, 99.99% of agreements reached at mediation will never have to go through a process where they need to be enforced. And yet the parties need to feel as though they will be enforced when they're drafting their agreements. So I had a discussion with one of the delegates at the convention, and the way that it worked. Michelle showed the photograph of the room where we were negotiating, and there were formal sessions where we were all behind our it's actually a little screen that has our country's name, and then when you click a button to speak, and they say, oh, you've raised your flag, and you get to speak, and you're translated into 6 languages. There was that formal portion, and as Michelle mentioned, there were also informal portions. So we had breaks where we would have some of the discussions, and for example, that break in the snow day in New York, and other breaks, there was a big breakthrough in one of the Vienna sessions. We did this over 4 years. And one of the discussions that I had during one of those breaks was where I said to one of the delegates who was on the other side, who was really concerned about helping people who wanted to get out of deals, that I said, you know, for me, the perfect convention is one that is never used. It's perceived by everybody to be workable. So when people reach their agreements in mediation, they then stick to their deals, and there's no need to go through this enforcement mechanism. And he was aghast and thought that was a terrible thing. Why are we spending so much time if we don't want this to be used? And for me, I said it's similar to a lot of the criminal laws. So in an ideal world, our criminal laws never have to be used, and that they're there to discourage behavior so that people abide by laws, and then there's no requirement to resort to them. So I thought it was important to give that background because in terms of the discussion about reservations, I think that's relevant. And at the UN, when they talk about reservations, and you've heard that term a number of times, reservations are, it's a term of art, and it means that the country that enters into the negotiation can reserve the right to do something. So there was you can see there on the screen, there was Article 8A is a really easy one. A country can make a reservation that the convention not apply if that government or government agency is a party to a deal. So the government may not want the convention to apply to a deal that it's reaching for whatever reason. For me, of course, I would think, why would you never want a deal that could be enforced? It doesn't even make sense. But if the government wants it, that's fine. The key, though, was B. And as Michelle mentioned, this is what we called the opt-in, opt-out debate. And really the issue here was, what should we do if parties entering into a settlement agreement don't put their minds to the issue of whether this agreement should be easily enforced? Should we assume that the parties entering into the agreement want their agreement to be enforced? Or should we assume that the parties entering into the agreement don't want their agreement to be enforced? Now, I may have framed that in a way that some of the people who were negotiating would say was probably not a neutral frame, and is a bit provocative, and to me is completely clear, because parties at a mediation who are settling their dispute and entering into an agreement, for me, it's clear that they assume that that agreement will be enforced, and they assume that they will be entering into an agreement that where people will carry out their obligations, and if people refuse to carry out their obligations, the party that is receiving benefit can then force the party that agreed to give the benefit to follow through with their obligations. But there were numerous people in the negotiation who said, no, we have to protect people who enter into agreements and don't know that it's really easy to enforce. They may not want that agreement to be easily enforced. And as I say, that didn't make sense to me. I didn't understand it. I can only imagine at the end of a mediation when if parties do put their mind to whether they want this enforced, and one party says, well, we should of course make this agreement enforceable, If the other party ever said, no, I don't really want it to be particularly enforceable, I want to be able to get out of it, that's a big problem. And as though some of you are mediators, I know that those of us who are mediators, we would say, well, wait a second. If you are thinking that you want to get out of this agreement, we should discuss it and try to reach an agreement that you don't want to get out of, that you assume will be enforced. So for me, it was very clear. When people reach agreements, they assume that the agreements will be enforced. And if they put their minds to, should the convention apply, they will obviously say yes, because the convention assists with the enforcement of agreements. But there were many people who said, and they had instructions from their governments to say, no, we want to protect people who reach a deal at mediation and then later don't want that to be enforced. They want to be able to resist enforcement. And for me, this particular issue was the most important issue that we were debating. And the reason why it's called the opt-in, opt-out debate is that it was framed so that should we require parties who are entering into a settlement agreement to opt into the convention, or should we only say that we're allowing them to opt out of the convention if they put their mind to it and say, we don't want this agreement enforced, we can opt out. But if they're silent and they don't opt in or opt out, does the agreement apply or does it not apply? At the end of the day, the compromise that was reached was that countries have the right to have a reservation, where the general rule is that if parties don't say in their agreement that the convention applies, and assuming that the two countries, or as the agreement calls them, states, as the convention calls them, states, assuming that those states are parties to the convention, then generally the convention will apply. So if they're silent, the convention will apply. What this allows, this reservation B, it allows the countries to say, for anyone who is entering into an agreement that where one of the states is our state, our country, we are requiring that if you want the convention to apply, you have to specifically state in your settlement agreement at mediation that the convention applies. Our hope, my hope, and I think the hope of many of us, is that as mediation becomes more accepted and better understood, no one will use this reservation. And the countries that feel right now the need to use this reservation, and those are generally the countries where mediation is less understood, that eventually over time they will not want to have this reservation anymore. But in the meantime, it's important for practitioners, and that's both mediators and lawyers who are participating in mediations, to realize that there may be countries who have made this reservation. So my suggestion to you is that it's safer for you when you're drafting your settlement agreements for international mediations to put a clause in there that says the Singapore Convention applies to this settlement agreement, so that if the parties want, you don't need to say this, but this is what, if you just need to say the Singapore Convention applies, and then that way, if the country has made a reservation and there is a problem with enforcement, the parties can still allow the Singapore Convention to apply to get their expedited enforcement of the agreement. So those are my comments, and Thomas, send it back to you. Thank you.
Thank you, Alan. Our next speaker is Mr. Ted Lim. Ted is a dispute resolution practitioner based in Singapore with 30 years experience as a dispute resolution counsel and 15 years experience as a commercial mediator. He is recognized in Who's Who Legal as a leading mediator, and also in his practice in commercial litigation. Ted serves as co-chair of the IBA Mediation Committee, board member of Singapore Mediation Center, and member of the IMI Independent Advisory Committee. Over to you, Ted.
Thank you, Thomas, and it's good to see familiar faces in the midst. I want to maybe approach this topic of ratification as a practitioner, and maybe start from a quick discussion on conceptually what ratification means to a practitioner, and and then maybe talk a bit about brass tacks of what that looks like if you have a international mediated settlement commercial agreement and you are seeking to enforce it in a ratifying state. Next slide, please, Thomas. So the starting point for our discussion must, of course, be Article 11. Article 11 lists the ways in which a state may become a party to the convention. You see, of course, Article 11.1, the starting point. First step is a simple signature by the state, followed by, you see Article 11.2, ratification. One of these processes that will allow a state to provide or indicate its consent to be bound by the Singapore Convention. So the focus, of course, is for this discussion is ratification. So let's ask ourselves, what is ratification? Next slide, please, Thomas. Under the Vienna Convention on the Law of Treaties, it defines ratification as an international act whereby a state indicates its consent to be bound to a treaty if parties intend to show their consent by such an act. So for a dualist legal system like Singapore, you will find that for the Singapore Convention to be binding and effective in Singapore, Singapore will first of all have to deposit, which is prescribed under Article 11.4 of the Convention, the instrument of ratification with the depository of the Convention, which is the Secretary General of the United Nations, and also enact domestic legislation passed by the Singapore legislature. Next slide, please, Thomas. At the current, to date, there are 5 states that have deposited their instruments of ratification. You will see there in this slide, Fiji, Singapore deposited on the same day, followed by Qatar, Saudi Arabia, and Ecuador. And because the Singapore Convention enters into force 6 months after the 3rd ratification, the convention enters into force on the 12th of September this year. So this is a photograph of Singapore Senior Minister of State, Edwin Tong, depositing Singapore's instrument of ratification with the Under-Secretary General for Legal Affairs, and together with a picture showing the United Nations Legal Council, deposit on the 25th of February 2020. Next slide, please, Tom. So this is Singapore's passage in ratification. Post-ratification, you will see that the Convention, Singapore Convention on Mediation Act, was passed by Parliament on the 4th of February, assented to by President on the 17th of February, and it came into operation on the 12th of September. At the same time, the Rules Committee worked on the Supreme Court of Judicature Singapore Convention on Mediation Rules, which came into operation also on that same date. Next slide, please. So I'm going to pause here for a moment and maybe give a little bit of flavor to what it looks like when you get down to brass tacks for those of us who are practitioners. And you know, we could use this as an exercise. I'm going to put up also the, if you want to have a look at the Act, you could either use the QR code to access the Act and the rules, or just click on the URL which I provided on the chat, and it will bring you to the Singapore legislation and the rules. But I think if you look at both the Act and the rules, you'll discover, I think, that simplicity is the order of the day. The application is a very straightforward and simple one for practitioners. The application, when you seek to enforce an international mediated agreement, settlement agreement, is done by way of, for common lawyers, originating summons filed on an ex parte basis. The objective of the application can be used as either a sword or a shield, and Joe will elaborate on this in the next segment. As what Michelle has explained earlier, the burden of proof is on the applicant. If the order is granted, the order may not be enforced until it is served on the party against whom settlement agreement is sought to be enforced or invoked, and 6 weeks has passed after the service of the order. If the application is contested by the party against whom the settlement agreement is sought to be enforced or invoked, then that party can furnish proof of the grounds for which the court should rely on to refuse enforcement. In that instance, then the burden of proof shifts to the party who's seeking to prove that the settlement agreement should not be enforced. This is something that Michelle also alluded to earlier. So when you look at the way in which Singapore has enacted the Act and the rules, and I suppose that there will be other legislation that may not look similar to the Singapore legislation. The words that Corinne used to describe the Singapore Convention, I think comes to mind, that the Singapore Convention offers a simple and clear mechanism to enforce international settlement agreements. Indeed, when I compare this act with the International Arbitration Act, it's a lot easier to navigate, and certainly the rules are also simpler if you're going to file an application to enforce an international mediated settlement agreement under the Singapore Convention. That I think is what I want to share with you. If you have any questions, I'll be happy to take that later on. And on that note, I hand it back to you, Thomas.
Thank you, Ted. We now have our next speaker, Mr. Joe Tirado. Joe is a dispute resolution lawyer with over 30 years of experience doing dispute resolution work. He is co-head of international arbitration and ADR at a leading Spanish and Latin American firm. And he has also occupied global leadership positions in leading firms in the UK and in the US. He is a solicitor advocate with full rights of audience before all civil courts. He is an accredited mediator, an exit conciliator, and panel member of a number of leading arbitration and mediation panels. Joe writes extensively and presents regularly on international arbitration and ADR at major international conferences, symposia, and seminars around the world. Over to you, Joe.
Thank you, Thomas, for that introduction, and thank you for the invitation to speak today. I'm conscious time is a little tight, so forgive me if I pick up the pace a little bit to hopefully cover the what I've been asked to speak about. Let me start with an apology for those who are expecting Claude, the well-known French mediator Claude Amar, to speak. Unfortunately, Claude, I understand it, is not well. He leaves enormous boots to fill. I will do my best to do that, but if Claude is listening, we wish him a speedy recovery. Obviously, the focus of the discussion so far has been entirely on the Singapore Convention. I have been asked to look at compare and contrast it effectively with the European Mediation Directive and to really highlight some of the key distinctions. So in order to do that, let me start, if I may, by just giving a little bit of background to the European Mediation Directive, or to give it its full formal name, the Directive 2008/52/EC of the European Parliament of the Council of certain aspects of mediation in civil and commercial matters, or much simpler, the EU Mediation Directive. This is the legal framework regulating mediation of cross-border, and by that I mean or international, and I'll come back to that in a moment, disputes between 27 EU member states. There were, until the beginning of this year, 28, of course, but at that time the UK was still part of the European Union. The only country that opted out of the directive was Denmark. So 27 signed up to the directive. Historically, basically what happened at the turn of the new century, the new millennium even, The institutions of the EU regarded the promotion of mediation within the EU as highly desirable. However, without formal legislation, it has proved difficult to establish predictable practices and equal opportunities for mediation across member states. So with that in mind, the EU adopted the European Mediation Directive in May 2008. So we're talking, it's not that new these days, about 12 and a half years ago, to govern the various mediation issues within member states. All member states, as I say, with the exception of Denmark, were obliged to bring provisions of the directive within a three-year period, that's to say by the 21st of May 2011. In Article 1 of the directive, that sets out the objective, which is to facilitate access to dispute resolution and to promote the amicable settlement of disputes by encouraging the use of mediation and by ensuring a balanced relationship between mediation and judicial proceedings, close quotes. It applies where two or more parties to cross-border dispute of a civil or commercial nature voluntarily attempt to settle an amicable, to reach an amicable settlement with the assistance of a mediator. Article 2.1 of the directive states that a dispute is, quote, cross-border, close quotes, when at least one of the parties is domiciled or habitually resident in a member state different to the other party on one of the following dates. That's either when the parties agree to use mediation once a dispute has arisen, when a court invites or orders the parties to attend mediation, or when the parties are obliged to use mediation under national law. The EU mediation does not extend to revenue, customs, or administrative matters, nor to disputes involving the liability of the state, nor to those areas of family law where the parties do not have a choice of applicable law. However, given the broad definition of cross-border disputes, the directive's provisions on confidentiality, limitation, and prescription, which I'll touch on in a moment, periods, also apply in situations which are purely internal at the time of mediation, but become international at the judicial proceeding stage. That, for example, if one party moves abroad after mediation fails. The directive does not impose an obligation on parties to mediate, although it does identify a number of potential advantages of mediation. Neither does the directive contain detailed guidelines for the conduct of a mediation. Rather, it provides high-level principles. It envisages that member states will create their own mediation guidelines in accordance with their own procedures. So just to highlight a couple of the key provisions, and they're not in numerical order, Article 5 gives a judge the right to invite the parties to have recourse to mediation if at any stage of the procedure the judge considers it appropriate. A judge can also suggest that the parties attend an information meeting on mediation. The intention is to encourage parties to consider using mediation without making it compulsory. However, individual member states are not prevented from introducing legislation to make mediation compulsory or subject to incentives or sanctions, provided that such legislation does not prevent access to the judicial system. The directive does not specify sanctions for failure to mediate, but neither does it preclude individual member states from introducing legislation for this purpose or prevent courts from imposing such sanctions. Article 7 reasserts the importance of confidentiality in mediation. The general position is that unless the parties agree otherwise, neither mediators nor those administering the process can be obliged to give evidence in relation to matters or information arising from or connected with the mediation. There are two exceptions to this. This is where overriding public policy considerations make it necessary, in particular when it is necessary to ensure the protection of children or to prevent physical or psychological harm, and where disclosure of the content of an agreement resulting from mediation is necessary to implement or enforce that agreement. Article 7.2 expressly provides that nothing in the directive prevents member states from enacting stricter confidentiality measures to govern mediation. Article 8 proposes that any limitation period should be suspended while the parties are engaging in mediation in order to guarantee that parties will not be prevented from going to court should the limitation expire while the ultimately unsuccessful mediation is taking place. This was perhaps unsurprisingly one of the most controversial articles of the directive. Article 4 relates to the encouragement of member states for training and development of mediation. Perhaps the key one to really flag is Article 6. This deals with enforceability of agreements resulting from mediation. The enforcement of agreements reached by way of mediation is perhaps the most important novel aspect of the directive. And as I say, you've got to remember, we're talking about over 13 years ago when it was being contemplated. Under Article 6, member states have a duty to, and again I quote, ensure that it is possible for the parties or for one of them with explicit consent of the others to request that the content of a written agreement resulting from mediation be enforceable. Compliance with agreements resulting from mediation should not, again I quote, depend on the goodwill of the parties, close quote. The directive obliges member states to set up a mechanism by which agreements resulting from mediation can be rendered enforceable if both parties so request. The choice of mechanism is left to the member states. The directive bolsters the status of a settlement agreement from cross-border mediation by providing that such agreement should be made enforceable unless either the content of the agreement is contrary to the law of the member state in which enforceability of the settlement agreement is requested, or the law of the member state does not provide for the enforcement of agreements with that specific content. Any agreement which has been made enforceable in one member state should be recognized and declared enforceable in other member states in accordance with community or national law. This means that since the agreement needs an official recognition from the competent public authority to be enforceable, the directive only provides for indirect enforceability of settlement agreements. This can make the process more time-consuming and costly and can impair the efficiency of mediation. I'll come back to the question of enforceability in just one moment. As an aside, I thought it might just be worth noting the relative success or otherwise of the directive during that period of nearly 13 years. Back in 2014, a study was conducted to try, at the request of the European Parliament, to basically look at the directive and to see comment on its uptake. Unfortunately, at that stage, there was a rather disappointing statistic that came out from that study that that mediation was being used in fewer than 1% of cases in the EU. So this is 2014, 1% of cases. Having said that, it's a real patchwork of story, because in 46% of EU member states, fewer than 500 mediations took place every year. The study put this down to the retention of voluntary approach to mediation. But in fact, the study found that there were over 10,000 mediations taking place annually in only 4 countries. So it's quite, well, as I say, a bit of a patchwork story. This caused concern, understandably, given the intention of introducing the directive in the first place. So there was further consultation and a determination to effectively, what they termed, reboot the directive, and a number of proposals were made. However, it's interesting to note that in 2018, effectively, notwithstanding the rebooting that occurred from 2017 onwards, the Legal Affairs Committee of the European Parliament were looking to see whether what effect this had on the uptake, and concluded that, quote, the directive remains very far from reaching its stated goals of encouraging the use of mediation, close quote. So I raise this only for to commend the fact that the directive exists. There has clearly been progress, but as that quote indicates, there's still some way to go. So just to, in the minutes remaining, to conclude by way of comparison, really the single biggest point to make, I think, in terms of comparison is the question of enforceability. Under the Singapore Convention, you have direct enforceability. And this is really where I think it gives a turbo boost to the mediation process and gives added value. As a result, also, we see a more streamlined procedure for the recognition of such agreements. where the role of the judge will be limited to verifying the conditions under which the parties' agreements has been reached. More specifically, the judge will have to declare it enforceable as soon as the following conditions are met, i.e. that the agreement results from a written document, the agreement arises from a mediation, it's in an international context, and relates to a commercial dispute. The other real point to make is, at the risk of stating the obvious, is scope. Clearly, I mentioned that 27, well, now 26 with the UK having left the EU signatories to the directive. There are 53 countries that have signed the Singapore Convention, so we actually have more countries involved, and of course the geography that it covers is far greater, so not limited to the European Union. In reference to the sword and shield that Tad mentioned earlier on, it is worth noting that the Singapore Convention provides that the settlement agreement with both a sword and a shield effect. The sword effect is the enforceability granted to agreements outside the EU, enabling parties to get their share of the agreement in case the other side has had a change of mind. But it also provides parties with proof of settlement in case they are being confronted with a claim on the same subject matter, a defensive shield effect. One should perhaps also note that this protection would also have been provided to a certain extent through official recognition under the EU law, but the Singapore Convention is in the long run likely to include more countries, and this without the need for official recognition. So, as I say, with apologies for a bit of a canter, there was quite a bit to cover, but I hope that at least gives you an introduction to the EU mediation directive and highlights some of the key differences with the Singapore Convention. So without further ado, back to you, Thomas.
Thank you, Joe. Very interesting topic just now. We have a few more minutes for discussion and questions. I'm now checking from the chat box on the questions. I think we have a couple of questions on the same topic, Joe, which is that, what will happen to the applicability of the EU mediation directive that you mentioned after UK exit EU in 2021? Would you like to take that question, Joe?
Well, I can answer that if I can, because
Michelle, please.
Yeah, Michelle can answer that.
I was struggling with the button.
I was sent the act by the Ministry of Justice withdrawing from the mediation directive. And bearing in mind that I had a significant part in drafting the directive, that was the height of insult, as I was firmly opposed to Brexit in the first place. But there's been a passed act with withdrawing us from the directive, I'm afraid.
Yes, well, exactly. That's my understanding, that we are out of it. Having said that, with all the twists and turns, anything can change. We're still negotiating. So theoretically, we may well be part of it. The only thing I would say in our defense is arguably the mediation directive was not, we were not one of the jurisdictions effectively that it was directed for in terms of encouraging. And we were clearly, I think, within the smaller camp of 4 jurisdictions where we see an active use of mediation. So in some ways, I mean, while it is disappointing, it sends the wrong signal. In practical terms, I don't think this is a setback within the UK for the purposes of mediation.
Right, thank you, Joe.
And arguably, with Brexit, this may be an opportunity to further promote mediation.
That's right.
I agree.
We've got one question for all of you, if you could all chip in, which is that, what do you think are the challenges for practitioners in using this Singapore Convention? Maybe who should take this first? I mean, it's a question for all of you. Anyone wish to take that?
I'm happy to start, and then somebody else join in. My view is that it means that mediators just have to be a little more careful when testing and engaging in evaluative mediation, which most of us do at some stage of the mediation. And I think the answer is to make sure that when a settlement agreement is being drawn up, the lawyers actually for each party explain the settlement agreement in full to their parties before they sign it.
Maybe I'll jump in. As I mentioned, I think it's important for practitioners to note in their settlement agreement that the Singapore Convention applies. And it could be a concern for practitioners if they don't do that. And it turns out that one of the countries has made a reservation so that there's a requirement to opt in. That could be something that could come back to haunt the practitioners. So for the sake of safety, my suggestion would be to always have a simple clause in the settlement agreements, and for mediators to suggest to the parties that they have a clause about the Singapore Convention applying.
And anyone else, Ted?
Well, I was going to say that, you know, if you have a party who is intent on finding ways to vitiate a settlement agreement, you look at the grounds for objection, and most of them would probably not apply. And the ones that you might find a reason to at least delay the enforcement would be to launch an attack on the conduct of the mediator. That's going to be a soft spot. And it might be that, you know, although notwithstanding what Michelle has said about the high barrier to prove that, it might be the only avenue for one to resist enforcement. But we'll have to see how this works out. I mean, certainly from the Singapore landscape, in the domestic regime, we've had at least one case where a High Court judge has dismissed challenge on the mediators' impartiality or allegations on impartiality. And I suspect the Singapore courts are going to be very robust in dismissing such challenges. But, you know, other states may not be as receptive. So we'll have to see how that pans out.
Thomas, I would just add, if I may, I mean, I'm conscious that we're probably preaching to the converted, but I mean, clearly, I think we can all be in agreement. Anything that promotes and reassures parties using mediation has got to be a good thing. The brutal practical reality of the Singapore Convention is that I think in reality, certainly in my experience, most people comply with their settlement agreement. And so we are talking very much about it. You know, I'm not sure, I've not seen any empirical evidence in terms of numbers, but this is really the exception where people are going to be wriggling out of a settlement agreement. So, and when I hear the term, what are the challenges? In reality, it seems to me a bit of a no-brainer. It's good, you've got this in the background, it's the hard work's being done for you. And for most parties, that's exactly what they want. They want to be able to know that they're going in. There will always be the recalcitrant party who will try and wriggle out of things. That inevitably, I think one has to try and go in with one's eyes wide open. But I think there's a danger of over-focusing and maybe presenting in a disproportionate light. This is by far, I think, a step in the right direction and a force for good.
Thank you, Joe. One last question. We still have 1 minute or so. That I would like to put this to Corinne, which is this. Based on the slide presented, there are now 53 countries who have signed up. In your view, Corinne, are there any main concerns or factors that some countries might consider which would prevent them from immediately signing up to the convention?
No, I think not that we are aware of. States, the signatories are going through the internal process, as Tat has explained, and it takes time. It's a lengthy process. So slowly, we have more states which are signatories who are becoming party to this convention. And for the other states that are not yet party to the convention, there are discussions ongoing in the EU among EU member states, including on the question of competence and whether states could take the convention separately or not. So there are debates in the EU. There are also more states have shown their intention from the Latin American and African countries to join. It's just a matter of process, and it takes a little bit of time for these instruments. So yes, and on the question that you just had before about the practitioners, I think all the practitioners we have wonderfully covered all the points, so I have nothing to add. Thank you very much.
Thank you. We are almost there at 6:31. I think we still have questions there, but then we are running out of time, and I think that we're almost there, and maybe I'll draw this to a close. And I wish to say thank you to all the panel speakers. It's an excellent discussion on this topic. And also, I would say thank you to the audience for locking in and listening in. So I will pass this back to the organizer. Is Jody still around?
Yes, I am. Thank you, Thomas. So this marks the end of Capsule 3. I would like to invite all the participants to join me in thanking the panel of speakers, Michelle, Corinne, Joe, Tad, and Alan. And last but not least, Thomas in moderating the entire session for us. Thank you very much. We still have 3 more capsules, and the next one will start at 7 p.m. Looking forward to see you all there. Thank you.
Thank you very much.
Thank
Goodbye.
you very much. Bye-bye.
Thank you all.
Thank you. Bye-bye.
Thank
Oh,
you.
it's lovely to see you. Jennifer, lovely to see you too.
Take care.
Thank you.
Thanks very much, Joe. Thank you, Corinne.
Bye-bye.
Thank you, Tat. And Alan, thank you very much. My love to Sari. Sorry.
Thank you, Michelle, for taking the lead.
Yeah.
Bye all. See you, Tad.
Bye, Joe. Bye, Alan.
Jody, to come to the next capsule, I have to log in again. Is that right? You're muted, love.
There's a separate link for that. Do you
Yes,
have
I've got it. I've got it. Yes. So I
Okay.
come out of this and come into the new one. Okay. And that's
Yeah.
the term in half an hour. Yes.
Correct.
Lovely. Thanks very much, Jody.
Okay, see you in a while.
Thank you very much, Tad. If you let
Sure.
me have the judgment, I'll be grateful.
Okay,
Thank you,
we'll send
Mr.
it to you.
Lim.
Bye,
Bye.
Judy.
How many participants do we have? It's over 100, I think.
Yeah, 110.
Great.
110
Well
for
done.
this one. Yeah.
Well done, Jody. And thanks, Sam, for doing the slides for me.
Okay, see you in a while.